have a lot of questions about just the probate. What all does probate entail? Because of course, some individuals do wills, some individuals like having a trust. So kind of what is probate? Like we hear about probate, we hear how scary probate is. Kind of what is probate? What's the cost of it? Why a person does a will, probate might not be the best for their situation. Probate might be a good idea in some situations. So we kind of want to go for probate when it comes to a will. Kind of what's that process? So heaven forbid, if your family has to go through something or you have friends that go through something, you can at least know or let them know kind of what that entails. All right. So yeah. What is really probate? So probate is court supervised process of distributing assets. So we have a judge that basically reads the documentation and lets everybody know his or her opinion about the document and who gets what, right? And it happens there's no trust, just a will. So even if you have a will, it goes through probate. If you have a power of attorney by itself still goes through probate. And with the power of attorney, once a person passes away, you can't make changes to the will, right? So a person might have a will that they did 8 or 9 years ago and things changed. They want other beneficiaries. They have a power of attorney. The power of attorney knows those changes that a person wanted to make. But when a person passes away, the power of attorney can't make any changes to that will. So it's important to get a will. We're not saying it's not important to have a will, but definitely having a trust and a will was the best. But a power of attorney by itself is not going to cut it. A power of attorney, as we talked about before, that takes care of decisions, financial wise, medical wise, when a person is living. But when it passes away, that stops and everything is frozen at that point, especially if you have a will. Power of attorney is good. The power of attorney can definitely make changes. The will is still going to go through probate, or you have a power of attorney, it still goes through probate. And the judge decides the timelines, the access, and the legal validity. So the judge, depending on how large the estate is, he or she is going to kind of dictate how long it's going to be. Now you can have individuals that can contest the will, right? If one person says, hey, I'm entitled to money, another person says, no, you're not, then you're contesting the wills. That's going to take longer. Access probate is public record. So everybody knows what you have. Everybody knows who's arguing. Everybody knows what percentages gets given to who. So it's public, and then also, what's valid in the will, right? Because you can say you want to do X, Y, Z, but the judge might say, well, that's not valid. You can't do that, and nothing can be done. So those are some of the not so fun things about probate. Another thing, probate is very costly. Individuals really don't understand how costly it is until they go through the process. So on the outside looking in, if I'm living a great life, I'm paying bills, things of that nature, if something happens, they'll kind of deal with it when I pass away. Yeah, you could think that, but it's going to be very, very costly monetarily, and then also very costly mentally, right? Having to take off of work days after days. If I got property in different states, whatever I say in the will might not actually be applied to another state because of state statute. So it's just very costly mentally and also monetarily. And when you include all the costs between court fees, appraisals, because yes, if it's in probate, you actually have to have your house appraised to see what's the actual value of it. You have to pay the executor. He or she has to be paid, even if a executor or your personal representative is actually a family member or a spouse, right? They have to get paid, especially if it's a statute state, which we'll talk about. Document prep and delays. Probate can cost in between 5 to 7% of the estate's value, especially when you involve real estate. So the typical kind of cost, attorney fees. So attorney fees are in between 3 to 5% of the estate value, especially if it's in a statutory state, which we'll talk about here shortly, like California and Florida. Florida is a statutory state. We might be state tax free. If I can talk, we might be state tax free, but the state of Florida makes money other ways, and one is being a statutory state. Court filing fees. Have to pay court filing fees. That's going to be anywhere between $300 to $1,200. Appraisal fees as well. If you have property, they have to have it appraised. That costs money. It's weird. Like, why am I having to have my property appraised when I want to pass it down to a family member? Because it goes through probate. So they want to know the actual value of it so that they can charge you the value of your property, which is crazy to think about, but that is probate. Then, of course, executor fees. That depends on the states as well. You have a personal representative that you've already named, or an executive you've already named. He or she doesn't have to take the money, but of course, depending on which state it is, they might have to and then kind of give it back. That's usually 2 to 3%. So if it's $100,000, I don't have a will at all. So that means the um, judge or the courts have to appoint that executor or personal representative. And the state's $100,000. That's another $2 to $3,000 given away just because, right? So it's important to have a will. Now, again, will still goes through probate, but from the pyramid of estate planning or the pyramid of just protecting, you want to have your living document. And your living document, of course, is your power of attorney that I always talk about. You want to have your will, right? But then you want to have a trust, which we'll talk about. And then also your quit claim deed to make sure that your house goes to the trust. So that's kind of the hierarchy. But probate court is very, very expensive. Okay, so we got a couple questions. I got a DM. What if a family member is the personal representative? Do they get paid? Well, it depends on the judge, right? So if a person has a will in place, let's say a person's husband passed away and the person's representative is the spouse, was put in the will, then I would think the judge would not, um, charge the estate when it's going to be the spouse's money anyway, right? Especially if they've been married over 10 years by law, it will go to the spouse. So if it's a spouse involved, then I don't think they would have to pay, but it's up to the judge. And that's the not so fun thing about, probate. It's really in the eyes of the judge to kind of make those decisions. So it's a great question. Okay, cool. So let me go back. Extra costs. Oh, too far, Mario. So extra costs of probate attorney fees. So when we have probate, we also have probate court costs. Then as well, we have to pay an attorney to get it out of probate, right? And this is one of the reasons why attorneys can justify charging people to do a trust for $5,000, $6,000. Now we don't charge that, but definitely that's how attorneys can justify it. If it's a $200,000 estate, or if my house is $200,000, and I'm charging, $200 to $500 an hour, and it's going to take me 10 hours, that's $5,000. Well, if it's going to take me 20 hours because it's, family members involved, people are contesting it, I'm going to get paid a lot of money. In that case, that would be, $15,000 to $20,000. So do I rather spend $5,000 on a trust on the front end, or do I rather have my family take money out of my accounts on the back end that's going to be $10,000, $15,000, $20,000? That's the reason why individuals in particular charge so much to do a trust, because on the back end they charge so much more money. Even a flat fee is about $3,000. But the two attorneys that we use for individuals that are going through probate, because with our estate planning, we help, but once you go through probate, it's already done. So the attorneys that we use, they both charge over $3,000 for a flat fee for their retainer, right? Of course, if it's more, then they'll charge you more, but just retainer alone is usually $3,500. So probate attorneys is very expensive, and it is what it is, right? You have to have an attorney to get it out of probate court. You just can't just do it yourself. You maybe can, but I don't know how far it's going to go. So yeah, and also percentage-based fees. So some charge you between 3 to 5% of the other state's value. So again, having a state that's 300,000 got a house that's $250,000, $50,000 in assets, that's 300,000 at 5%, and that's $15,000. $15,000 is a lot of money. That's just going to an attorney. And all you want to do by having a will, you just get money. Why does a court system have to be involved to help with the process? Like, in my humble opinion, is definitely a way for attorneys to get paid and also the court system to make money. But again, having a trust kind of supersedes that as well. We have any other questions? Let's see. So we had a question. Does the judge charge extra fees if they have to adjust the guardian if family is having conflicts? That is a great question. So if it's conflicts involved, it's going to stretch out the probate process. So probate can be as quick as 6 months, as long as 2 years, just in general, just depending on, If the courts are backed up, judges involved, the attorneys at certain times. So it's going to be a 6-month to 24-month time period just in general. But then to your point, this was from Stephanie, if it's conflicts, then that means it's more hearings. So if it's more hearings, then that means it's going to be more time. If it's more hearings, then that means the probate attorney is going to have more billable hours. If they have more billable hours, that means more money that you have to pay. So yes, if it's guardianship conflicts, then that's going to be an issue. Now, when a person has a will, in that will, it should be a part of the will that talks about the guardian. So if I have minor children, right, let's say either the husband or the father of the child or the mother of the child is out their lives for whatever reason or whatever the case may be, you want to make sure that you have a guardian inside that will. For us in our estate planning documents, is in the core of a will, but you definitely want to have that in the will. If not, then it's up to the courts to decide who gets it. Is it the godparents? Is it the mother or father of the person who deceased? Is it an older brother or sister that's over 18? So it's the courts decide that, but it's going to cost extra. And if you have family members kind of bickering who gets the child, that makes it even worse. So having a will put in place is important, but then having a trust as well in place to talk about that if something happens, kind of who gets the assets, how we're going to help pay for the care of that child is very, very important. But to answer to your question, it will be an extra charge if it's a conflict when it comes to a child involved. So that's a great question. Let's see, I had a direct question. Okay, so a person had a question: what are the 5 financial benefits from a financial planner's perspective? The benefits of getting a revocable living trust. Great question. So number one, taxes, right? So when I have a trust, it bypasses taxes up to $23 million if a person's single, up to $40 million if it's a married couple. If I don't have it, then my estate is subject to federal taxes. So that's number one. Number two, just the mental stress of your family, having to take off of work, having to go to court, like that's just mentally draining, right? And what if you have a job that's not flexible? Now you're taking off of work, you're not getting paid, you might get laid off. So yeah, that's that. From a deed standpoint, if you have a trust, you're able to bypass everything, do a quick claim deed. So now you get to move money from you into your trust. And then when a person passes away, the person in your trust gets it. So you don't have to worry about who gets what from a house perspective. Then the two other things cost, right? It's better to do a trust up front than pay an attorney on the back end. It's also better to do a trust up front than pay court costs and fees on the back end as well. So those would be the 5 reasons why. That is a great question. Another question, also I had someone that had to get a bond for $1,500. Wow. So it sounds like, Steffi, if I'm not mistaken, the person was going through probate. They couldn't afford it. So it's like you have to bond a person out of jail. They had to get a bond to actually pay for probate to go through the process. Am I correct with that, Stephanie? That assumption?
It's to secure the property. Like, let's say if they have a piece of real estate, then here in Georgia, they may require you to have some type of surety bond. And then the surety bond, they go by credit and everything like that. So they would charge you accordingly. So the judge said that you have to get a bond to secure the house, which the house was $2,000. So they have to get a bond. It's like an insurance protection or what have you. So a huge cost because it's $1,500 and he had to pay $7,000 on top of that as well.
Oh my gosh. So 7,000, well, basically $8,500 when it's all said and done. Right. That's the hidden cost, right? If a person had a trust, and they had a quick claim deed attached to that trust, they won't have to worry about that. So a lot of times when people think, well, I'll worry about getting the trust down the road or when I get sick or I have my family, think about it when I pass away. It's costing the family more time and money doing that way. And typically, it's your money, so it's going to be paid for out of your money anyway. So it's better to be paid for now while it's cheaper compared to doing that process. And then, of course, people are grieving, so people might be making rash decisions and paying extra money instead of going to one bond. If they went to 3 or 4 bonds, then it would be cheaper if they found somebody cheaper, but they want to get the process done. So they just pick one and move on. So it's always better to plan and get the trust beforehand. Great insight, Stephanie. Great insight. Also, fees, $200 to $500. And look at that. I don't know if you in TV, Stephanie, but that's a good segue when it comes to bond premiums because if they're required, it could be up to 1% of the estate annually. So if the estate is in the probate process for 2 years and a bond is needed, then that means we're paying twice, not just once, because it's assessed annually. So yeah, and delayed costs. And assets can be tied up to 9 to 24 months as financial loss. So just think about now the market has recovered, and nobody knows the future, but definitely, we believe in the stock market. We believe the stock market is going to be higher, a year from now, higher 2 years from now, and going forward. But what if I had my money tied up in a 401k and my 401k was aggressive and the market went down? It's important. A client of ours that passed away. They had their money stuck in. So here in Florida, we have a retirement plan called the Florida Retirement Services for state employees. We had a person that had their money 2022 stuck there. They passed away, didn't put any beneficiaries on their paperwork when they moved from the pension to the investment plan. So it was stuck for about a year and a half. 2022, the stock market had its second worst year in 25 years. So their investment plan value went down dramatically. And because it was frozen, no one knew how much it was. We knew the money was in there, but no one knew how much it was. No one knew how much it went down. You can't call a 401k provider or a financial institution to get information about what's in the account, what's it invested in, because it's frozen. They can't give any information unless you're the executor. And even with the executor, it's just information dealing with beneficiaries and paperwork, it's not actually making changes. So for that particular person, when the family got the money in early 2023, it was about a 20% loss. Now the market went down by almost 40%, so it could have been worse, but still, if it was management involved, who was able to kind of make some changes, maybe it would have been a 10% loss or a 5% loss. And for them, it ended up being about $30,000 of losses. Now, with the market being down in 2022, it would have been some losses, but maybe $10,000 losses, not 20,000. So again, that's probate. So yeah. So an example, right? So if I have a home that's worth $4,000 and it's going through probate, it's going to be 5% in combined fees. So that's basically $20,000 of losses compared to if I got a trust done and that trust costs, let's say, 3,000. Let's kind of make up a number. Different attorneys charge different things for trust. We charge a lot less than $3,000 to do a trust through us. And for however you want to charge when you want to charge. But let's just say it was $2,000. Well, you doing a $2,000 trust while you're living is a lot less expensive than having your family go through the process of losing $20,000 on the back end. So that's $20,000 less to the heirs, not counting the lost time in the stress. We had a couple questions. Oh, my battery's about to die. Okay, I'm good. Okay, cool. Let's see. So Tanisha had the question, why do they need to bond? So they need to bond because it had to be, the property had to be guaranteed, right? Because if it is no beneficiary, nobody, who guarantees that something's going to happen? So it has to be some type of guarantee there. Make sure that the estate is paid, and that's why you get a bond to secure that. So hopefully that. Stephanie answered that question. Look at that. Okay, teamwork makes the dream work. All right. So great question, person. What about for a immigrant person? Ooh, I don't know the answer to that one. I don't know the answer to that one because you're based on your social security number. So if a person is an immigrant, and again, I'm not getting into immigration, I'm definitely not an immigration attorney, and I don't know anything about immigration laws, but I think first you have to depend on if they have a social security number, they have a work visa, so that'd be more of an immigration attorney. But to that point, if a person is an immigrant, another reason why a trust would be very beneficial because you can make sure that everything that you own is passed down without going through the court system. Because a trust is a private document, and everything kind of gets passed down on the back end, which we'll talk about. It has to go through a court system, and you're maybe illegal. And not saying I'm not getting immigration. If the person is illegal, they illegally inherited property, then I don't know how that's going to work. So for individuals that are immigrants, another way why you want to get it out of the court system. You don't want to be involved in the court system, and the trust bypasses that. So great question. but they got I-10. Okay, if they got a social security number, then they're fine. So if you're an immigrant, but you have your I-10 or your SSN number, you're fine. It still goes through probate though. But yeah, you don't have to worry about anything being seized if you have your social security number. So yeah, but I would still recommend a trust, of course. But great question, iPad. All right. So who pays for the will and probate? So the estate pays for it, right? But someone must pay upfront costs. So court fees and attorney's retainer, you can't say, hey, attorney, I'm going to pay you on the back end. It doesn't work like that. They get paid up front. Give me my retainer. Court filing fees must be paid before anything can be transferred. So what if we don't have the money? So again, as Stephanie talked about, that's where the bail bonds come in to kind of help, protect that. Or if no one has the money, then the estate stays frozen. And if the estate is frozen, then things just stack up. Right. And we see this a lot when it comes to heir property or, tax sales. Right. Over time, we have property, it's there and bills are stacking up. I'm not paying the taxes. Nobody's getting it out of probate. And then years later, now it's a estate sale with a house and somebody else buys the house. They pay back the back taxes and now it's theirs. It happens all the time. If a trust was involved and a quit claim deed was put in place, we'll bypass that. So yeah, so this very, very, what's going on, Billy? Billy from Florida. All right, cool. So yeah, yeah, a lot, and I'm pretty sure you guys have heard horror stories or actually you guys put one in the chat if you heard of a person, just so everybody kind of see like it happens. Put one in the chat if you guys know of a person or have a family member that lost their property basically because of it being stuck in probate. Let me change. My battery's almost dead. Hold on 1 second, you guys. Intermission. Yes, like I said, you guys put a one in the chat if you guys heard a horror story. You have a family member that unfortunately, lost their house because of the probate process. Okay, yeah. So you want to DM me the person who put number one and let me know kind of what happened. We kind of talk about it. And that's horrible too. Actually, almost happened to my family. So we have property in North Carolina. It's my grandfather's father's property, and it was just a mess. Like for years, because it's just land and it's overgrown, and for years nobody wanted to pay. My grandfather had 6 siblings, so some of the family's heirs paid taxes on the property, some didn't, and like for 3 years people just stopped paying. So it was a tax bill. So we had like a family meeting about 6 years ago on Zoom. Zoom wasn't that popular, and we just kind of made a decision to keep it or not keep it. We just kind of had to keep it, and we ended up paying back the back taxes. But yeah, if they would have got paid, we would have lost that property. So it definitely happens. It definitely happens. What's the difference between a private trust and a public trust? It is no such thing as a public trust. A trust is a private document. So when a person has a trust, I recommend a person, this is for everybody, I don't recommend that you actually file that trust with the clerk of courts. If you have a quit claim deed, you want to file that quit claim deed with the clerk of courts. But the trust by itself, you don't want to file it because now that trust becomes public record. Right. So a trust is private. So when the person does a trust, they notarize it. We recommend, whoever your financial advisor is, have he or she keep a copy of it just in case. Your tax professional, have he or she keep a copy, and your insurance agent, those 3 individuals that are your business professionals, they keep copies. And then also you want to have a copy to your successor trustees. Your successor trustee is a person that basically takes care of that trust and make sure what happens when you pass away. So they're the ones that should have copies of that trust. But the actual trust document by itself, never recommend filing that with the clerk, of course, because it's public. So yeah, so I hope that kind of answers that question. Every trust should be private. So yeah, but another great question. Yeah. So who pays for the trust? As we talked about, is frozen. Then also family can't afford it. They have to borrow money or they have to sell property just to start the probate process. But if the property is the property in question that's going through the estate, you can sell that, right? So you have to sell another family has to sell a property or take a loan against their 401k, which I have seen clients of ours that had families that somebody passed away, didn't have a trust. So they took money out of their retirement account. And when you take money out your retirement account, you have to pay taxes unless it's a Roth IRA. So they have to pay taxes on that. Now, even they might be refunded the money, but you're not going to be refunded taxes. And anytime we take money out of an IRA, it also increases our taxes, right? So let's say I take out $1,000 from my traditional IRA and because I took that $10,000 out my traditional IRA, now from a tax standpoint, I'm not taxed as if I made $50,000. I'm taxed as if I made $60,000. So that's more taxes I have to pay at the end of the year because I took money out, and you're not gonna get that back, right? So yeah, it's unfortunate with probate. Also delays. Some things can be foreclosed on because sometimes if family's bickering, nobody's going to pay the mortgage. Because when it's in probate, guess what? That mortgage still has to be paid. If the mortgage is not being paid, then of course the bank could come in and eventually foreclose. Now, will it take 6 months? It takes 2 years. We know foreclosure is a long process. But if the house is foreclosed on, so yes, it's definitely probate is definitely frustrating. All right. So we had another person, unfortunately. When my grandfather passed away, I was in high school and no one knew what to do. So my mom and her siblings lost their family home. Oh my gosh. Wow. That's horrible. So yeah, so to the point. The person who said that, you could DM me back. How long ago was that? Yeah, the family home. That's horrible. Yeah, so probate is not fun. Not fun. Not fun. Another question. How does a person fund a trust? Is it through life insurance, 401k, etc.? So the person's, I'll get to that answer, Terrence. But then the person said, over 25 years ago in Philadelphia. Wow. So you think about 25 years, Philadelphia. That's north. Now we're south, of course. I would imagine that's today. That's probably 400 to $500,000 of a value of a house, right? Let's say that house was maybe $100,000 25 years ago. I'd imagine that house today is probably 500, $600,000. So when people talk about generational wealth, losing a house in probate is a very quick way to lose that generational wealth for the rest of your family. So I'm very, very sorry to hear that. Very, very sorry to hear that. So we had a question. So how does a person fund a trust? So when a person has a trust, the attorney or a platform, you're going to get a trust funding guide. That trust funding guide tells you how to fund a trust depending on your assets. If a person has a 401k, I don't recommend anybody putting their trust as the beneficiary of a 401k. Now you can't put a trust as the owner of a 401k because it's a retirement plan. Just like if it's a traditional IRA, it can't be the owner. The owner is the person. It's a retirement plan. But the reason why you don't want to put a trust as the beneficiary is because of taxation. You see, if I have a 401k, when the money passes down to my beneficiaries, they don't get taxed when they first get the money. Now, after they get the money and they take the money out, they pay taxes at that time. But what if they don't take money out for up to 10 years? Because you can get money inherited to you and have 10 years to have it grow without paying taxes if you want to. Well, if I put it into my trust and my trust is a beneficiary and it goes directly into that trust account, then instantaneously it's going to be taxes paid to move it from the person who passed away 401k to their account. So I wouldn't recommend anybody putting a trust as a beneficiary. You want to have the beneficiary, if you have 4 kids, you want to split it 25% each. If you want to have 25% each per child. If you have a spouse, the spouse is the primary at 100%, and then the children are secondary. You want to have it that way. But no one should actually have a entity, which is a trust, as the primary beneficiary of a 401k or any retirement plan for that matter. Now, inside of the trust documentation, you can say, you don't want them to spend all the money at one time. So it's documented. Now they can do it because it's not in the trust name, it's in their name, but you're going to have it documented. But I wouldn't recommend anybody putting a 401k beneficiary as the trust. If it's a life insurance policy, then yes, the beneficiary of that life insurance policy should be the trust. If I have a account at the bank, as I talked about before, you want to have a POD, which is power on death at the bank, or a financial institution is called a TOD. You want to have the primary beneficiary of the trust as well. So all those accounts you want to put as the trust as a primary beneficiary, but not as a 401k. As life insurance, yes. I have another question. Can I put the trust as a beneficiary of a pension? Um, so when I have a pension set up, it's usually no person that I can elect besides my spouse, right? So when I retire and I have a pension now, what companies give pensions now? But when I retire and I have a pension, they usually only give you, three options. The first option is you by yourself, and if you pass away, your family can't get it. That's a beneficiary option or no survivorship option. Two, they have a spousal option where the spouse will get anywhere between 50% to 70% of your pension. So let's say your pension is $1,000. Your spouse will get in between $500 to $700, right? Now, when your spouse passes away, he or she can't pass it down to the family. It stops at the spouse. And then also some pensions have it where if you have a child that's disabled, then the child gets that pension up to age 25. So those are usually kind of the three options when it comes to pensions. But you can't put in that instead of my spouse gets the pension, I want it to go to the trust. It doesn't work like that. It's only the spouse or a child if the child is disabled up to age 25. So you can't put the trust as a beneficiary of a pension. Now, if you have like a lump sum pension and you roll it over into an IRA, for example, then yes, um, I would recommend again having the trust as beneficiary, but you could put beneficiaries on at that end, but you can't put a beneficiary on a pension. You guys are asking amazing questions, by the way. So keep the questions coming. Keep it coming. Keep it coming. And so again, we talked about if the family can't afford it. So I talked about this briefly, but what is a statutory state in probate? So it's actually more cost that a person has to pay in probate if it's a statutory state. So statutory state is a probate state in where an attorney and the executor fees are set by law. So it's not a judge saying, hey, the spouse is the executor, so there's no extra charges. No, it is set by law. Nothing we can do about it. And it's typically a percentage of the gross estate value, not the equity. Very, very important, right? We had this question a few times on different seminars. What if I have equity in a house, right? So if I have a house that's 1,000, but out of 500,000, I owe 300. Is it based on that 200,000 that's equity on the total 500,000? It's based on the total value of the house, which is 500,000. So yeah, this means, oh, look at that. This means if a house has a mortgage, the fee is based on the full market value, not what's just left after that. So the full value, even if I'm upside down on the property, it's based on the full market value. And also families often overpay probate in these states without realizing it. So I know I'm kind of hammering home why probate is not good. It's good to have a will. We want everybody to have a will, but a will is not enough because a will goes through probate, and probate is a nasty, nasty process. So common statutory probate states: California, New York, Illinois, Oregon, Georgia, Florida, Texas, Missouri, Iowa, and Nevada. So again, because they're common statutory, it's in law. It's the law on the books how much the executor, is going to be paid. So again, more money out of the to a person, which means less money to the actual family. So yeah. Then you guys have questions, let me know. Example in Florida. So again, if an estate is worth $500,000, which estate is worth $500,000, in that case, the attorney would get 13,000. So from an attorney standpoint, they're making more money. They could have either sold you a trust before you pass away and made $4,000 or $5,000, or waited 10 years later, you pass away to the same attorney that your family talked to 10 years ago, so you're going to use them, and now they're charging 13. They make more money that way, right? So that's why attorneys justify how much they charge for a trust, because they know on the back end it's going to be way more. And so for you guys who use our software, you have your clients use our software, definitely you can definitely charge. I just went out. You can definitely charge, whatever you want to charge, and it's definitely justified because attorneys charge a lot more. The executive gets $13,000. So again, if it's court appointed or if it's a family member, they get $13,000. Of course, they can give it back to the end all be all person who gets the money, but it's still extra cost. So that's basically $26,000 before court costs and delays. And I said before, even with a property that has a $300,000 mortgage, it's based on the property value, not the equity. So it's not based on 300,000, it's based on 500,000. So wait for the court systems to get money. We had some more questions. And these are great questions, you guys. So can putting the house in a trust help to delay foreclosure process? No, it cannot. So just because you put a house in the trust, that helps, but it doesn't solve the problem. Solving the problem is having a quick claim deed where you deed over from the owner to the trust. So if somebody passes away, it goes directly into the trust and then to the beneficiaries. But that still doesn't help from a mortgage standpoint because the mortgage company owns the title, right? It's really theirs. It's the deed, but it's really theirs until the mortgage is paid off. So just because you put it into a trust and you do a quick claim deed, you still have to pay the mortgage. If you don't pay the mortgage, you get foreclosed on. And this is referenced in the St. Germain Act of 1982. So the St. Germain Act of 1982, if anybody has any, want to do research, definitely research it. Saint, S-T, Germain, not with a J like the Jackson 5, but Germain, Germaine, of 1982. Basically, you can move your house from your name into a trust and through quick claim deed, and you don't have to pay off your mortgage. So even though you're moving it from one owner to another, it does not have to be paid off. You can still have a mortgage and do that, right? So that's good. However, with that, if you do that as the person who got the house in first place and being titled when you title it over to the mortgage company, you still have to pay the mortgage. So yes, it could be deeded to somebody else, but you're still responsible for it. And if not, then they can go through the proceedings of foreclosing. So that is a great question. Had another question. Does the state also does that mean it's a sovereign state? So Shay, I don't know about sovereign states. Maybe like a sovereign citizen? Like that doesn't apply. I know people say they're sovereign citizens, but you still have to abide by the law. So I don't know what sovereign state is. If you can maybe give me some more color with that question, Shay. We had another question. Can the platform add holding? Yes. So if a person uses our platform, so the question is, can our Relax Estate platform add a holding LLC that's registered in Wyoming to fund the trust if the trust was established before the holding company was established? So who asked that question? Get their information, and then that's a side conversation. So the answer is yes, you can, but it's just it's a process. So I want to walk you through it step by step. So get the person's information, and then we can talk offhand. So another question: what if the house is paid in full but has a loan out for solar panels or construction? Yeah. So we're going to talk about that now. Because usually when they also have what you call first position. So the person, it happens all the time. A person does like a hard money loan, right? Where I have the house paid off, but I want to do some renovation, my credit bad, so I use a hard money lender that lends me money. But he or she or that company is in first position, meaning that if I sell the property, I have to get paid first that company has to get paid first before you get the proceeds. So even if the house is paid off, if it's a construction loan or solar panel loan, they're in first position. And I know because I got solar panels. I did it. And I can say, right, even though I'm a certified financial planner, I'm telling you guys, probably the worst financial decision I made was getting solar panels. I live in Jacksonville, Florida, so we're in Duval. Duval does not give you money towards having, even though they use my solar power, right? They don't give you money for it. Our bill went down by like 20%. I thought it was going to go down by like 80%. So for every $100, I'm saving about $20. I thought I would save $80. It was just a horrible financial decision. And they were expensive too. I did it because we got a tax credit. So we bought it in 2020 because when President Trump, he didn't get reelected, but if he did, he said he was going to stop the solar panel tax credit. So we did get a nice tax credit, and the tax credit means that whatever you spend, you get that back. So let's say I didn't, but let's say I spent $10,000 on the solar panels. I'd have got all $10,000 back on my taxes compared to it was a tax deduction. If I spent 10,000, it would have been 2,500. So I got more than 10,000. It costs way more than that. But just like the break even, I'm gonna have to, which perfectly we will. That's our forever home. But like doing the break even, we're not gonna like break even what we paid for those solar panels probably to like 2040. So we have another 15 years, and I thought we would break even now, 5 years later. I say that to say, anybody thinking about getting solar panels, I would recommend against it. It's probably one of the worst financial mistakes I've made, just to be honest with you guys. So yeah, but the answer to your question is that they will be in first position. So even though you sell the property, whatever loan that you owe, solar panels, they're going to get that money before you do. So great question. So another question we got time. Can creditors collect through probate, and what is the process, right? Yes. Creditors can and they will collect through probate. Yes, yes, yes. They can file claims against the estate. So to Shay's point, if a person has the house paid off, if the creditors make a claim against that, they have to get paid before you get the proceeds of that estate in probate. So yes, those are creditors. If accepted by the court, and the court is going to accept it, right? They get paid before the heirs. Even old debt sometimes be reinforced. So if it's an old debt that's out of sight, out of mind, that could come back too, and it's up to the judge to say yay or nay to that. So another reason why we want to do a trust is that some of those debts, can't go after somebody that don't have any money if it's in the trust, right? So what is the credit process in probate? Well, first off, typically the court set a deadline for 3 to 6 months. One of the reasons why probate court is at least 6 months, because if probate was like 1 month, it doesn't give the creditors enough time to, find out if you passed away. And it's a system that all banking and financial institutions have to find out when people pass away. Like, so unfortunately, we're blessed that, have, over 1,000 clients nationwide with our investment firm. But unfortunately, people pass away. So a lot of times we don't find out, not from the family members a person passed away, but we find out by the financial institution that we use, because they have to do a check every single day on a person, passed away by the social security number. So they do that same check as well. And then they check if the person passes away, then they go through the process of what was owed, and then they definitely get into the local county clerk to go through the probate court process. But it is about 3 to 6 months that they have, and that's why probate is not quick. That's why it's at least 6 months. The executor must notify known creditors, right? So the executor, he or she is being paid through the probate court filing process, so they have to notify the creditors. Now, excuse me. Now they usually notify all the creditors, especially if it's a family member. No, I don't know, but they're supposed to. But like I said, typically the creditors, they're going to find a way to get that money in life or in death. So even if they're not notified, they're going to be doing notifying themselves. Claims reviewed and either accepted or rejected. So it's up to the courts to either accept or reject it. But of course, the credit card companies, the loan companies, they have the documentation, they have the paperwork on file. You might not have it as an executor, as a family member, or the probate attorney might not have it, but they do. Typically, if it's not a false claim, they're going to be that's going to be and unpaid debts may force a sale of property. So if the only thing that we have is our property, no other assets, and then the property can be sold. Because if you owe somebody money, using the solar panels for example, I got my house is worth 100 grand. I owe somebody 30 grand. I'm gonna get my 30 grand. Well, you're gonna have to sell that property, right? So now that's gonna be tedious, because again, it's appraisals involved. You're gonna have realtor fees, and that's usually 6%. As a seller, I'm paying 6%. So $100,000, that's $6,000 that goes to the realtor to sell the house. Then also, if it's a quick situation, what if the housing market's down, right? I have to sell it. You know, I can't just hold on a year or 2 years and wait till the housing market goes up, or if it's gentrification in the community and it's going to go up over time. I can't wait. So I'm typically selling it at a lower price than what it should be. So for those reasons, again, getting a trust and not going through probate is definitely the way to go. Um, yeah, thank you for the support. Yeah, awesome. Um, okay, cool. All right, Shay, cool. Um, awesome. Most of the bills are okay, Jay. Okay, cool, Shay. Okay, awesome. All right. So you guys keep the questions coming. A few more slides. And also, what is the actual claim? So upon death, you have the creditors. They can file against the estate, and the common ones are medical bills, of course. Can't get around that. Credit card debts. Can't get around that. Personal debts, utility bills, taxes, and taxes. If you don't pay those, and they can take our house after a while. Funeral expenses, the funeral home, will put a claim against your stuff in probate if you don't pay for the funeral. Typically, what they do is they actually notify if there's life insurance involved. They get all the life insurance money, right? And they know what they're doing, right? The first thing they ask is life insurance, because they know with the 4K and stuff, it's going to take a while to do a lien. It's not guaranteed. It has to go through probate. But the life insurance, how life insurance works, life insurance has to be paid to the funeral before you get it. So the first thing they ask is life insurance. You got life insurance, they're going to do whatever they can to have you, give you discounts, things of that nature. If you don't have life insurance, who knows if they're going to take you or not. Legal fees, of course, business debts. So if you own a business and the business is not doing well, or you owe something from a business standpoint, they're going to come after you as well. These claims are typically paid before any distribution to heirs. So again, all these debts have to be paid before the heirs receive anything. And can creditors get money from a trust? No, because a trust is where we control everything and own nothing. So generally, creditors cannot access assets in a trust if it's properly funded in a revocable trust or a irrevocable trust. So with a revocable trust or irrevocable trust, if it's funded properly, where the trust owns it, not the actual person, then, it's tough for the creditors. Unless, again, house is different. House is different because from a title standpoint, they can foreclose on that. So like credit card debts, personal debts, things of that nature, utility, if it's in the person's name, if I have a utility bill in my name, but all my assets are in the trust, well, the utility bill is in my name. So, that's just a charge off for the utility company. So again, another important reason why a trust helps, because if you have outstanding debts, they can go after it. But if it's going through probate and it's in your name, then yes, they can go after it. Trust avoid probate, so creditors are not notified by the courts. And this is why I answered the question earlier, why you should have your trust as a private document. Because usually creditors have 3 to 6 months to make a claim. After that, it is what it is. So if it's a private document, how can they make a claim when they don't know? It's a private document. But once you file that trust with the clerk of courts, as if you're going to file your quick claim deed with the clerk of courts, then it's a public document. So since it's private, they don't know. So a legal, not illegal, this is a legal way to bypass paying off some debts. Not all debts, but some debts is getting a trust. Exception, fraud. If I'm a fraudster, if I'm a scammer, then I got to pay for taxes. City, state, federal, municipal. When it comes to taxes, it don't matter if it's in a trust, if it's in your name, your mama's name, your daughter's name, wherever you move your money to, Uncle Sam gonna come on knocking on that door and get that money. So if I owe taxes, then I am going to pay, no matter if it's in a trust or somewhere else. Last few things. How a trust works when you pass away. So 3 simple steps to transfer assets without probate courts. Number 1. So the person passes away, they have a trust. So we know pass away goes through probate. If I have a trust, and the immediate control transfer goes to the successor trustee. So when I have a trust, we put in there co-trustee, and then we also put in successor trustee. So a co-trustee is typically spouse, right? So if I'm married, I do a trust. typically do the trust together. Now, you don't have to do the trust together, right? If you're married, you don't want to include your spouse in the trust. You want to make decisions all about your stuff and your stuff alone. You can do that. Now, if everything is kosher in the household, we recommend that you do a trust together. Just like when you file your income taxes, it's best for you to file your income taxes together instead of separate. But different strokes for different folks, and it is what it is. But your trustee and your co-trustee, those are ones who are owners of the trust. You own the trust and you control it because again, with the trust, you own nothing, but you control everything. So if I have a co-trustee and let's say the husband passes away, now the spouse is the remaining trustee, then of course it's her trust and what she says goes and she can still make changes if it's a revocable trust. When both of them pass away, then the successor trustee is now the person over the trust. Now the successor trustee, he or she can't make any changes. The only people who can make changes to a revocable trust are the trustee or co-trustee. Once the successor trustee, they can't make any changes. The successor trustee can't be like, hey, I'm going to give all the money to myself. I'm going to change things with a beneficiary. All the money goes to me, not to somebody else. It doesn't work like that. The successor trustee can only, do the transfers, but they can't make any changes. But there's no court. There's no delay. The person named the successor trustee takes over immediately. Immediately, trustee and the co-trustee passes away. They get it immediately, and then they follow the instructions written in the document. They cannot make any changes, but they do have to follow the instructions. Step 2, the trustee collect and manage the trust assets, right? So they have access to bank accounts. They have access to investments. They have access to property. However, if you do not put those items in the trust and the schedule of assets, number one, and number two, if you don't change the beneficiaries from a person into the trust, they have no access. So let's say we have a bank account. We have a bank account. It's a joint bank account. Both people pass away and no beneficiary on it. Even though we have a trust, let me have access to it so we can move the money from the people that passed away to the beneficiary. It's not going to work because there wasn't a beneficiary on it. So that's why it's very important. You want to fund the trust. And funding the trust just means that you put the trust as the beneficiary. If I have an investment account, not an IRA, but just an investment account that has stocks in it. If I pass away, it gets frozen. If I have a trust and there's no beneficiary as the trust on that account, it's still frozen and it still goes through probate, even though I have a trust. So it's very important that every account that you have, you do either a POD or a TOD to make sure that the trust is the primary beneficiary. Not a 401k like I've talked about, but any other just investment account or stock account. Same for the property, right? You want to do a quick claim deed as I talked about, and a quick claim deed, of course, passes it over to the trust, and the trust gets to the beneficiaries. How do you make it private? So Stella Thomas, great question. How do you make it private? A trust is already private. So we just don't want to make it public. And we don't want to file our trust with the clerk of courts to make it public. So it's many people in this Zoom call, clients, right, of ours that have trust, but they're not public, they're private. So as long as you don't make it public, your trust is always going to be private. Another question, even though we have a trust and it is funded, do we have to let the county or city or file? No. No, Shedrick. So the only thing that they need to know is the quick claim deed, where you want to file the quick claim deed where the ownership of the house or the grantor goes from the person who owns the house into the trust. That's the only thing that needs to be filed with the clerk of courts. But the trust by itself, that does not need to be filed, and I would not recommend anybody file a trust with the clerk of courts. Not at all. Great questions, you guys. So great questions. Another question, can pay bills, manage real estate, keep the estates running smoothly. So again, since they are in the trust and we have the trust funding guide and we funded the trust accordingly, then they're able to make a decision, right? Because they have the documentation, like the bank says, hey, you have a beneficiary, the beneficiary is the trust, and then they have a copy of the trust, of course. Well, really, the bank only need the trust certification. So with every trust package, you have the trust funding guide, you have the trust, you also have the trust certification. So when a person goes to the bank and changes the beneficiary from their name to the trust as the beneficiary, not their name, but their beneficiary, and the trust being a beneficiary, they'll ask for the certification of the trust, which says that the trust is certified within that state. They take that and they update it. Now, just because the trust is the beneficiary, you still own it. You still own the bank account. You still own the house. You still own the investment account. You still own the life insurance policy. You own everything. But from a beneficiary standpoint, it goes directly to the trust. And able to do that, you want to give the bank, the financial institution, the life insurance company, and make them the primary beneficiary. You want to give them the trust certification. Trust certification. So you guys remember that. In my mind, y'all can put that into the chat. Trust certification. That certifies that the trust is legal in that state, and they use that to update the beneficiaries. You don't want to update the ownership, right? You still want to be the owner of your life insurance policy. You still want to be the owner of your accounts. So you make all the decisions. You have all the control. But if you pass away with that beneficiary being the trust, then that's where the successor trustee pops in. They have access to bank accounts, investments, and property. They use the trust documents and death certification to handle everything because the banks, they do need to see a copy of the death certificate so they could transfer it over from the person who passed away's name into the trust. So they do need a death certificate. And you can pay the bills, you can manage real estate, and keep everything running smoothly, as I said. The number 3, assets are distributed to the beneficiaries as instructed. So the trustee distributes everything according to your wishes. So again, a house as example, right? I have a quick claim deed. So the house transfers to my 4 beneficiaries if it's at 25% apiece. So now each person owns 25% of the house. It's done smooth with no probate. If I have a bank account and I got 2 beneficiaries, I have $10,000 in that bank account. Well, then it transfers into that trust, and then the beneficiary can either get the money, or if the trust says put it in the trust fund, so they can't spend all the money at one time, it would then be put into a trust fund, and whatever the trust says goes. But it's very, very easy, just like transferring money, right? Very, very easy process. No court hearings, no delays, no public record. So every single trust is private unless you file it to be public. But no delays, no public record. This can happen in weeks, not months, not years, like probate. And that's it. That is it. So we all bow our heads, our eyes. Dear Lord, thank you for your love. Thank you for your blessings. Thank you for being in our lives. Thank you for allowing everybody on this call to be sane, to be healthy. May you continue to bless them, bless their friends, bless their family, bless their businesses. May you continue to be in our lives and touch us in the ways that you can. In Jesus' name we pray. Amen. Well, thank you guys so much.